Hello there and welcome to Courts This Week. I'm Dina Osha. In this special edition, we bring you top stories of legal proceedings from courts, from lower and subordinate courts to high courts and Supreme Courts. We bring you selections of major legal proceedings which made headlines this week. In the next half an hour, we will inform and update you of all the important proceedings from the week. So let's start Courts This Week. The Supreme Court has dismissed the review petition filed by 6 ministers from 6 different states against the 17 August order dismissing pleas to postpone the NEET G exams as scheduled in September. A bench comprising Justices Ashok Bhushan, B.R. Gavai and Krishna Murari dismissed the petitions filed by 6 ministers, each from West Bengal, Rajasthan, Maharashtra, Chhattisgarh, Punjab and Jharkhand. After hearing held in chambers, the petitions filed through Advocate Sunil Fernandez stated that the SC orders fails to secure the safety, security and right to life of the students, candidates appearing for the NEET G exams. The review petitions had asserted that the August 17 ruling and the NTA's decision to conduct these exams amid pandemic is flawed on the following board contentions. It failed to secure the safety, security and rights to life of the students, candidates appearing for the NEET G exams. It has ignored the teething logistical difficulties in conducting the examinations on the proposed dates. It has failed to balance the competing but equally important aspects of conducting the examinations and securing the safety of the students. The plea highlights that 25 lakh students will cumulatively appear for the 2 exams, even as India records over 3.31 million COVID-19 cases. The petitioners have submitted that while the centre had adequate time to ensure the safe and successful conduct of the examinations, the intervening months from April to September 2020 were characterized by inactions, confusions, lethargy and inertia. The Supreme Court has allowed the telecom companies to pay adjusted gross revenue charges within a period of 10 years. The bench of Justices Arun Mishra, S. Abdul Nazir and M.R. Shah laid down the time frame within which the telecom companies are required to clear their AGR dues in the line with the court's October 2019 judgment. The Supreme Court has given 10 years' time for staggered payment of adjusted gross revenue-related dues by telecom giants including Vodafone, Idea, Bharti Airtel and Tata Teleservices. A 3-judge bench of Justices Arun Mishra, B.R. Gavai and Krishna Murari in its verdict today said that the telecom firms get 10 years to clear their AGR dues with installments to be paid by February 7th of every succeeding year. The court has warned that telecom companies that any default in payment of their annual installments will accrue interest and non-payment and will also invite contempt of court's proceedings. The court has shown agreement with senior advocate Hari Salve's submission during the hearing that the questions of whether spectrum can be a subject matter of IBC proceedings should be decided by NCLT first. The court has therefore directed NCLT to decide on the issue. The Supreme Court on August 24th had reserved its judgment in the matters regarding durations for staggered payment of adjusted gross revenue related dues by telecom giants. The court had been hearing telecommunications companies undergoing IBC proceedings on the larger questions of whether spectrum can be sold under IBC proceedings and liability of companies towards IGR dues of companies whose spectrums they are sharing. On this aspect, the court held that whether spectrum can be sold or not should be decided by the National Company Law Tribunal at the first instance. These questions had arisen for considerations when the bench was considering the bona fides of the ailing telecom companies as regards payment of their dues vis-a-vis their respective IBC proceedings, while the DOT had argued that the spectrum cannot be sold. While the DOT had argued that the spectrum cannot be sold, the telecom companies had argued that the right to use spectrum purchased through an auction is an asset and this rights or license can be subject to IBC proceedings. The Supreme Court on July 20 had reserved its order on the timeline of the staggered payment AGR related dues by telecom giants including Vodafone Idea, Bharti Airtel and Tata Teleservices. The court had heard parties on liability and time frame for making the payment and noted that while hearing the matter, attempts were made to wiggle out of the liability like asking for reassessment and recalculations. The court before today had not decided the reasonable period for staggered payments of AGR dues, while the government had proposed 20 years. Telecoms like Airtel and Vodafone had asked for at least 15 years. Airtel's AGR demand was Rs 43,989 crores, out of which it paid Rs 18,004 crores. And Vodafone Idea has paid Rs 7,854 crores out of its total AGR demand of Rs 58,254 crores. Bureau Report. The Supreme Court is gearing to resume the physical hearing after a long gap. COVID situation has necessitated clamp down on physical hearings and the holdings online proceedings. Now the Apex Court has issued standard operating procedure to facilitate physical hearings. The Supreme Court had issued standard operating procedure for hearing of matters through physical appearance. Initially, physical hearings shall commence only in 3 courtrooms and the same may be increased or reduced as the situation may warrant. Only a limited number of advocates, parties in person shall be allowed to enter into the courtroom at any given time, and in cases where the number of parties is more than 1 AOR and 1 arguing counsel per party, will be allowed entry. Entry of the counsels, parties or such other stakeholders to appear for such limited physical hearings will be through daily special hearing passes, which will be issued by the registry on the basis of authorization by the concerned advocate on record. Entry into the high security zone through proximity cards, long-term passes shall be suspended, and only advocates, parties in person, clerks or other stakeholders who have been issued special hearing passes shall enter the high security zone through the designated gate after subjecting themselves to the thermal screening. On entering the high security zone, advocate, parties in person would proceed to the staging areas, vacant courtrooms as may be designated, and wait for their turn to enter respective courtrooms where physical hearing of their respective cases may be scheduled, and they would proceed only through the movement of corridors created and demarcated for the purpose. On completion of hearing of their respective cases, the advocates, parties in persons, clerks, etc. shall move out of the high security zone through the movement corridor and exit from the designated gates. Advocates, party in persons having more than 1 case for physical hearing in the courtrooms shall be issued separate special hearing pass for each case, and after hearing of 1 case is complete, they may wait in the designated staging waiting areas for the purpose for appearing for the next hearings. Earlier this month, the 7 Judges Committee of the Supreme Court had recommended resumptions of physical hearings in a limited manner. Bureau Report. In the contempt case taken by the Supreme Court against Bhushan for his 2 tweets, a bench headed by Justice Arun Mishra sentenced him to pay a fine of Rs1, which is to be deposited with the Supreme Court registry within September 15. In case of default to deposit, Bhushan will have to undergo imprisonment for 3 months and will be debarred from practice for 3 years. Justice Arun Mishra, reading out the operative portions of the order of the sentence, observed that the statements given by judge to press are irrelevant for the consideration of the sentence, as judges are not supposed to go to the press. The Supreme Court has sentenced Advocate Bhushan to a token fine of Rs1 in the contempt case against him for his tweets criticizing the judiciary. On August 25, the bench of Justices Arun Mishra, B.R. Gavai and Krishna Murari reserved its order on the Bhushan's sentencing after finding him guilty of contempt of court for his tweets on the judiciary. While pronouncing the verdict, Justice Mishra said, "Judges are not supposed to go to the press. Their comments outside the court should not have been relied on." The bench went on to note that it had given Bhushan several opportunities to express regret for making his contemptuous statements. It also stated that Bhushan publicity to the events surrounding to the contempt case by going to the press. It said, court's decision should not be preempted by publication of opinion in the press. The court further deprecated Bhushan for publicizing his statements in media before they were considered by the bench. In this matter also, we not only gave an opportunity for him to apologize, but also directly and indirectly persuade the contemner to express regret. This was not heeded to by the contemner and gave wide publicity to his statement and gave media interviews, which further brought down the dignity of the court, the bench observed. However, the bench ultimately saw it fit to impose a token fine of ₹1 on Bhushan. The bench made it clear that if Bhushan defaults on payment of the fine, he may be sent to prison for 3 months and may be debarred from practicing for 3 years. Bhushan had filed a supplementary statement reiterating his position to stand by his tweets and has refused to apologize. When the supplementary statement was considered by court, senior advocate Rajiv Dhawan had urged the court not to make Bhushan a martyr by imprisoning him. Dhawan, who was representing Bhushan, had urged the court instead to send out a general message and not punish Bhushan. Attorney General K.K. Venugopal, on the other hand, proposed that Bhushan be let off with a warning. The court, however, pointed out that AG Venugopal and that Bhushan did not express regret but instead chose to reiterate his position of not apologizing for the contentious tweets. In a candid dialogue that followed between the bench and the lawyers present at the hearing, the court expressed the hurt and the pain caused by the institutions when such allegations are made. On August 14, the Supreme Court had found Prashant Bhushan guilty of criminal contempt of court for 2 tweets criticizing the judiciary. The court had initially fixed August 20 as the date for determining the sentence to be imprisoned on Bhushan. However, the court had deferred the matter further on August 25 after the August 20 hearing to give Bhushan another chance to tender an unconditional apology. Bhushan, however, refused to apologize, instead filed his restatement, and the effect of the same was considered by the court and then judgment reserved. Bureau Report. Justice Arun Mishra has retired from the Supreme Court of India on 2nd of September. He was the second senior most judge after Justice N.V. Ramana, who is the next in line to be the Chief Justice of India. In his 6-year stint under the 7 different Chief Justice of India, he was involved in a number of high-profile, politically sensitive cases.
Chief Justice of India S.A. Bobde and senior member of the bar bid farewell to the Justice Arun Mishra, who retires as a judge of the Supreme Court. As per tradition, Justice Mishra shared the bench with CJI Bobde on his last working day. In a short farewell speech, Justice Mishra said that whatever he could do came from the supreme power of this court, he said. I always try to borrow the weapon of power given to me by my learned brothers. All of you were the power behind whatever I have done. Paying tribute to the bar, he said, I have learned so much from the members of the bar. So many branches of law I have learned from the bar member. You can master the fact, but there are so many local laws and interpretation of those by lawyers. Justice Arun Mishra said that over the course of his career as a judge, he has dealt with every case with his conscience. Sometimes I have been very harsh in my conduct directly or indirectly. Nobody should feel hurt. Analyze every judgment and don't color it this way or that way. If I have hurt anybody, then please pardon me. Pardon me. Pardon me. CJI Bobde marked that it was the very first time that he and Justice Mishra were sitting together and would be the last time too, he said. It has been a privilege to have Justice Arun Mishra as a colleague. It is a peculiar thing that this is the first time I am sitting with him in court and this happens to be his last time. You have been a beacon of courage and fortitude in discharging your duties. Attorney General K.K. Venugopal, Solicitor General Tushar Mehta, Supreme Court Bar Association President Dushyant Dave and Supreme Court Advocates on Record Association President Shivaji Jadhav were among the lawyers logged into Court 1 to address Justice Mishra on his last day in office. While Attorney General Venugopal addressed Justice Mishra as the iron judge of the Supreme Court, other law officers wished him well for his second inning. The Attorney General said, "It is disappointing that this farewell is done through video conferencing. We are hoping he will be in Delhi. After all, he is only 65 years of age. I have had a good relationship with Justice Mishra for the last 30 years. He is the iron judge of Supreme Court. We will miss him in Supreme Court and we wish him good health." Justice Arun Mishra's tenure after elevation to the apex court in July 2014 has been eventful, and he leaves the court as one of the most controversial judges in its history. Even his final days in office proved headline-worthy, from the Bhushan contempt case to the adjusted gross revenue AGR rule, which have sparked debate across the country. Bureau Report.
And the Allahabad High Court had said that Dr. Kafeel Khan's speech at Aligarh Muslim University on December 13, 2019 amidst the anti-CAA protest that led to his arrest and subsequent detentions under stringent provisions of the National Security Act does not disclose any effort to promote hatred or violence. Accordingly, it has revoked the NSA charges against Dr. Khan. The order of the detention dated 13 February 2020 passed by District Magistrate Aligarh under the NSA Act and confirmed by the state of Uttar Pradesh have been set aside. The extensions of the period of the detentions of the detainee Dr. Kafeel Khan is also declared illegal.
The Allahabad High Court has set aside the detention of Dr. Kafeel Khan under the National Security Act (NSA) and ordered his release, while allowing the writ petition filed on behalf of Dr. Khan and setting aside the order of detention. The division bench of Chief Justice Govind Mathur and Justice Soumitra Dayal Singh declared the writ petition for the reason given above is allowed. The order of detention dated 13th February 2020 passed by District Magistrate Aligarh and confirmed by the state of Uttar Pradesh is set aside. The extension of the period of detention of detainee Dr. Kafeel Khan is also declared illegal. A writ in the nature of habeas corpus is hereby issued to release Dr. Kafeel Khan, the detainee, from the state custody forthwith. On 11th August, the Supreme Court had asked the Allahabad High Court to decide within 15 days the plea for the release of Dr. Kafeel Khan. Dr. Khan has been lodged in Mathura jail for an allegedly provocative speech at the Aligarh Muslim University in the backdrop of protest against the Citizenship Amendment Act. While passing its order, the Supreme Court had observed that the matter concerning personal liberty have always been prioritized by the apex court. In light of the fact that this matter involved Khan's personal liberty, the same must be disposed of expeditiously, the apex court said. While ordering his release today, the Allahabad High Court found that even prima facie, Dr. Khan's speech does not disclose any effort to promote the hatred or violence. It also nowhere threatened peace and tranquility of the city of Aligarh. The address gives a call for national integrity and unity among the citizens. The speech also deprecates any kind of violence. The High Court also took note that Dr. Khan had not been given proper opportunity to give a representation against his detention. In this regard, it was found that neither was Dr. Khan given a transcript of the speech on the basis of which he was detained, nor was he given a device to play a CD of the speech. Such non-supply of material violate a precious fundamental right of a detainee enshrined under Article 22 of the Constitution. On this count also, the detention of Dr. Kafeel Khan deserved to be set aside, the court said. Moreover, the bench found that Dr. Khan was not served the order extending his detention either. The court therefore proceeded to rule that both Dr. Khan's detention and the extension of this detention was unsustainable in law. Dr. Khan's mother challenged his detention under the NSA Act as illegal before the Allahabad High Court and filed a habeas corpus petition for his release. Senior advocate Dilip Kumar represented Dr. Khan's mother, and additional advocate General Manish Goyal appeared for the state. Bureau Report.
Delhi High Court has refused to provide injunctions against the movie Gunjan Saxena, the Kargil girl, in a plea moved by the central government claiming that the said movie has wrongfully depicted the Indian Air Force in a bad light. While refusing to grant relief, the single bench of Justice Rajiv Shakder noted that the movie had already been on the Netflix platform for long and it is now too late to grant injunction.
The Delhi High Court has refused to grant an order of interim injunction against the online streaming of Gunjan Saxena, the Kargil girl, in the suit moved by central government and Indian Air Force. Filed by Union of India and the Indian Air Force against the producers of the movie, Dharma Productions, the plea sought court's direction to restrain the producer of the movie and any OTT platform to showcase it either privately or in public domain. The central government also demanded the withdrawal of the film from all social media platforms, electronic modes, and even from the publicity campaign. The court said injunction cannot be granted because the movie is already out. Not being shown in cinema theatre is not good enough. You should have come at the first instance. While making Flight Lieutenant Gunjan Saxena as a party to the suit, a single-judge bench of Justice Rajiv Shakder ordered that the Indian Air Force be deleted as the second plaintiff. Appearing for the central government, Additional Solicitor General Sanjay Jain argued that Gunjan Saxena, the Kargil girl, showed the Indian Air Force as an organization which practiced gender bias. Contending that the movie damaged and dented the reputation of the Indian Air Force, Additional Solicitor General Jain remarked that the movie made the armed force a subject matter of ridicule in India and abroad. Seeking an order of interim injunction to take down the movie from the streaming platform Netflix, Additional Solicitor General Jain inter alia submitted that neither was an NOC obtained from the central government for the release of the movie, nor were the concern flagged by the Indian Air Force addresses by the makers. Appearing for Dharma Productions, senior advocate Harish Salve submitted that the movie was only inspired from the life of Gunjan Saxena, claiming that he has already seen the movie. Senior advocate Salve added, "The Air Force comes out in glory. There is no organization which does not have gender issue. Anything said in criticism is not slander. Haven't we seen gender bias in our profession? You can't pick 4 scenes and say slander. A letter from the Chief of Staff does not curtail free speech." Senior advocate Neeraj Kishan Kaul for Netflix informed that the movie was shown to the Indian Air Force in February and even the script was shared. Senior advocate Amit Sibbal also appeared for Netflix. The court, at the very outset, cleared that it was not inclined to grant an injunction in respect of a movie which has already been released. During the course of the argument, the court recalled the spycatcher case before the House of Lords and asked Additional Solicitor General Jain if he knew what the newspaper headline said the next day after an injunction was granted. The court noted that the movie had been streaming on Netflix for days and remarked that the centre should have moved the court sooner. While assuring that the concern raised by the centre would be looked into, the court granted the defendant 10 days' time to respond to the suit. The matter would be heard next on 18 September. Karan Johar and Hiru Johar were represented by senior advocate Rajiv Nair. Bureau Report.
Well, that's all in court this week. Thank you so much for tuning in. Keep watching APN and stay safe.